Hi, and welcome to Business 116. This is Chapter 20 notes. Just a couple housekeeping items. Make sure you're checking Moodle at least twice per week at a minimum. Preferably once per day is the optimal time you should check Moodle, but check Moodle at least twice per week. There's a lot of information on there. And as I said the first night, we'll be trying to stick to the schedule as much as possible, but obviously, as I said, I travel. As obviously we are holding this class through a web video, if you'll check that twice a week, it would be great. Also, any new students, if you haven't given me your contact information in form of a good phone number that I can reach you in case I'm held up in an airport or can't make class, I'd like to be able to call you or text you and let you know if we're having class or not. So if you have not given that to me, please email me at shughes, Hughes 18 at triad.rr.com. Okay, so we'll go ahead and get started with Chapter 20. The learning objectives for Chapter 20 are distinguished between negotiable and non-negotiable instruments. Describe drafts and checks and identify the parties to these instruments. Describe promissory notes and certificates of deposits and identify the parties to these instruments. 4. Describe how negotiable instruments are endorsed and transferred. And finally, distinguish between blank, special, qualified, and restrictive endorsements. So chapter 20 starts on page 396, and I will try to follow the book as much as possible. One of the quotes that I always like, it was a quote in 1803, and Judge Chambers, actually on the Supreme Court, actually said this quote. He said, "The great objective of the law is to encourage commerce." And that was Judge Chambers commenting on a case, Bill versus Thompson, in 1803. I think that's a great quote. I think that summarizes up business law overall for us, and it's one of my favorite quotes. So let's go ahead and get started. Negotiable instruments. To qualify as a negotiable instrument, the document must meet certain requirements established by Article 3 of negotiable instruments of the Uniform Commercial Code, or the UCC. Now, there's really 4 requirements in this. One, the commercial paper or the negotiable instrument must be in writing, and it must be signed by the maker or the drawer. And we'll get into who the maker is and the drawer is in a moment. There must be a promise to pay a fixed amount of money, and number 3, it must be payable on demand or at a specific time. And number 4, payable to either the orderer or the bearer. And again, we'll discuss what the orderer and the bearer is in a moment. But 4 requirements have to be met to be considered a negotiable instrument. Now, a negotiable instrument is also called a commercial place or a commercial paper. So, what is Article 3? You're probably wondering from your Business Law 1. I remember hearing that in Business Law 1. But basically, Article 3 of the Uniform Commercial Code establishes rules for creation, transfer, negotiation, enforcement, and liability of those negotiable instruments. So, again, for negotiable instruments, if the requirements of Article 3 of the UCC are met, a transferee who qualifies as a holder in due course takes the instrument free of many defenses that can be asserted against the original payee, and we'll get into that in a moment. In addition, the document is considered an ordinary contract that is subject to contract law. So remember from Business Law 1, your elements of contract law. You have to have an agreement. An agreement is between 2 or more people. You have to have consideration, which is typically monetary or money. You have to have and it can be personal. That consideration can be personal property. Again, money. It can be real property. And remember, real property is land or anything that's fixed to the land. That's really the official definition of real property. And number three, you have to have contractual capacity to enter into that agreement. In other words, I could not be in a mental institution and enter into this agreement, or I could not be found mentally incapable of taking care of myself and enter into an agreement. So you have to be contractual capable of entering into the agreement. You have to have a lawful object that you want to form a contract on, meaning that I can't form a contract with a hitman, so to speak, because that's unlawful. That's illegal. That's a crime. So the negotiable instrument or the contract in this case again has to be a lawful object. So you can let's turn over to well, before we get to that, you can read about the UCC in your book on page 189. So that kind of gives you a little bit more information about the Uniform Commercial Code. So the functions of negotiable instruments really serve the following. Is there a substitute for money? They're a credit device. And in America, we really couldn't function without credit. When's the last time you went to pay for something and you used your ATM card or your check card? Very rarely, myself in case in point, do I carry cash on me. It's very convenient to carry a check card. It enables you to purchase things that you normally could not purchase, meaning that hopefully you have more money in your checking account than you would carry cash. So it's a very convenient service. And it also, negotiable instruments serve as a record-keeping device. So again, negotiable instruments substitute for money. Number two, they're a credit device. And number three, they're a record-keeping device. Most purchases that individuals make based on statistics is they make those purchases from negotiable instruments instead of cash. So let's read on page 398 in the book about, under the contemporary environment, a little bit about negotiable instruments. It's right in the middle of the book. It's on page 398. It's under the contemporary environment, revised Article 3 of negotiable instruments of the UCC. So, although negotiable instruments have been used in commerce since medieval times, the English law courts did not immediately recognize their utility. To compensate for this failure, the merchants developed rules governing their use. These rules, which are enforced by local private merchant courts, became part of what is called the law merchant. Eventually, in 1882, England enacted the Bills of Exchange Act, which codified the rules of law for the merchant. In 1886, the National Conference of Commissioners of Uniform State Laws of the Uniform Negotiable Instrument Law in the United States. But by 1920, all the states had enacted the Negotiable Instruments Law as law, but the rapid development of commercial paper soon made the law obsolete. So Article 3, commercial paper of the UCC, which was propagated in 1952, established rules for the creation of, transfer of, enforcement of, liability on negotiable instruments. All states and the District of Columbia have replaced the NIL with Article 3 of the UCC. In 1990, the American Law Institute and the National Conference of Commissioners on Uniform State Laws repealed Article 3 and replaced it with Article 3 negotiable instruments of the UCC. The new article, which is called negotiable instruments instead of commercial paper, is a comprehensive revision of Article 3. Revised Article 3 is used as the basis for this in the following chapters on negotiable instruments. So, I think negotiable instruments are a big part of our commerce, as we've already talked about momentarily, and we'll talk about that further as the night goes on. But I want to get back to why I read Revised Article 3 in the book. Obviously, you can read. I hope you can at this level. I'm sure that you all can. But this is sort of how the lectures flow. I generally lecture and then we'll read some out of the book. What I'll do is I'll pick different people in the class to read different sections. And I feel like with the lecture notes and reading from the book that you get a better idea of what we're trying to talk about. So I'm trying to stay with how I normally would lecture and conduct the class. So that's why I read that piece to you. So types of negotiable instruments. Again, Revised Article 3 of the UCC recognizes 4 kinds of negotiable instruments. You have a draft, you have a check, number 2, number 3, a promissory note, and number 4, a certificate of deposit. So, drafts. A draft basically is a 3-party instrument that is an unconditional written promise by one party to pay a second party to pay money to a third party. So if you can picture a draft, you have a drawer of a draft, you have a drawee of a draft, and you have a payee of the draft. So it's very similar to a check. So if you've got your checkbook, go and get your checkbook out. So as you're looking at that checkbook, and you can go ahead and stop me here and we'll pick back up. So hopefully you've got your checkbook. So if you're looking at your checkbook, the pay to the bank generally is the drawee who owns the money, also called the acceptor of the draft. The payee is the person that you're actually paying the money to, and the drawer is the issuing party. So the drawee is basically the bank who owns the money. The payee is the person who you're writing the draft to, and the drawer is the issuing party. So hopefully that sheds a little bit more light on what a draft is. So you have really 2 types of drafts. You have a time draft and you have a sight draft. And basically, a time draft is intuitively what you think it is. It's a draft payable at a designated future time. Now, a sight draft is a little bit different. A sight draft is payable on sight. It's also called a demand draft. A sight draft arises when credit is extended for the sale of goods. So again, there's 2 types of draft. There's a time draft and there's a sight draft that we have. Another type of negotiable instrument is a check. We're all familiar with what a check is. We use checks in our everyday life, although it's not as much as we used to. We've went to credit cards and ATM cards, check cards. But a check is really a distinct form of a negotiable instrument. It's drawn on a financial institution, a bank, and payable on demand. So again, look at your check. You've got your drawer, the drawee, and the payee. Now, promissory notes can be also a negotiable instrument. Basically, a promissory note is a 2-party instrument that is an unconditional, I say again, an unconditional written promise to pay money to one party. There's really 2 different people on the negotiable instrument. There's a maker of a note, and then there's the payee of a note. The maker of a note is the borrower or who promises to pay back the promissory note, and the payee of a note is generally the lender. It usually occurs. A promissory note usually occurs when one person borrows money from another person. So there's different types of notes. There's a time note and a demand note. Now, let's talk a little bit about what security is. So, oftentimes, if you're going to borrow money from an institution, then they want some sort of security or collateral. If you have ever purchased a car or purchased a home, then especially in your younger life, you may would have had to got your parents to sign for you. But if you did not, then maybe you would have to put up some collateral. The collateral being for the car, maybe you would the title of the car or the rights to own your house if you defaulted on it. And some lenders sometimes require this, and more often than not, in today's economy, the lenders do actually require a security or collateral. Another type of negotiable instrument is called a certificate of a deposit or CD. Again, this is a two-party negotiable instrument that's a special form of note created when a depositor deposits money at a financial institution in exchange for the institution's promise to pay back the amount of the deposit plus an agreed upon rate of interest at the expiration time. Now, there's really two parties again to this, and of the CD, certificate of deposit. There's the maker of the CD, which is generally the institution, and there's the payer of the CD, which is the depositor or the lender. So again, a certificate of deposit is it's a two-party negotiable instrument. A depositor is going to deposit money into another financial institution as for a promise to pay plus agreed upon interest rate. A CD that's less than $100,000 is typically called a small CD, and a CD or certificate of deposit that's greater than $100,000 is typically called a jumbo certificate of deposit or jumbo CD. So, again, I want to reiterate what a negotiable instrument is. Again, a negotiable instrument must be in writing. It must be signed by the maker or the drawer. It must be an unconditional promise or order to pay. It must state a fixed amount of money, not require any undertaking in addition to the payment of money, be payable on demand or at a definite time in the future, and be payable in order be payable in order or to the bearer. Okay, so that's a little bit of summary of negotiable instruments. If you look in your book on page 403, under the contemporary environment, we've got a nice little section there at the top of the book that's authorized representatives who can sign negotiable instruments. So I'm going to go ahead and read that again. If we were in class, then I would obviously ask someone to read it, but I'm going to go ahead and read this section. So a maker or drawer can appoint an agent to sign a negotiable instrument on his or her behalf. For example, corporations and other organizations use agents, usually corporate officers or employees, to sign the corporation's negotiable instruments. Individuals can also support agents to sign their negotiable instruments. A maker or drawer is liable on a negotiable instrument signed by an authorized agent. The agent is not personally liable on the negotiable instrument if his or her signature properly, unambiguously discloses his or her agency status and the identity of the maker or drawer. In case of an organization, the agent's signature is proper if the organization's name is preceded or followed by the name of the authorized agent. So, real good example on the page on top of page 403 of who is an authorized agent to sign negotiable instruments on our behalf. So let's summarize a little bit on again back to that section. Authorized representatives can sign negotiable instruments. Some of the key points for negotiable instruments. You can sign a negotiable instrument by making a mark. If you remember several years ago, there, the best analogy I can give is the rock star used to be called Prince, and he changed his name just basically to a mark. Uh, in order to be official, that mark has to be a matter of public record. So I couldn't, for instance, just go around and say and just sign my name by S. Unless it's a matter of public record and I've actually filed it in the local courthouse. So I have to file that in the local courthouse. So I thought that was interesting. Um, so, negotiable instruments, Article 3, revised Article 3 of negotiable instruments, provides variable interest rates on notes for negotiable instruments. And this comes into play for, obviously, for notes payable. And basically, a variable interest rate is an interest rate on a loan over time. Let's see, another interesting fact is so a requirement of a negotiable instrument is you cannot require any undertaking in addition to the payment of money. So basically what this means is the promise or order to pay cannot state any other undertaking to do an act in addition to the payment of money. So example, you would pay, say somebody's going to buy or is going to build a building for me, then I'm going to pay for that building, and that would be the payment of the building. But the negotiable instrument would not say it's going to be I'm paying for the building and I'm going to provide a service because somebody built a building for me. Basically, I'm paying for the building only. You can have a prepayment clause in a negotiable instrument that allows for early payment. You can have an acceleration clause, but if you default, you can ask for a addendum that will allow you to pay the amount of money owed plus some interest in the future. An extension clause and basically is what you're trying to do. You're trying to get an extension on the maturity to pay of the negotiable instrument at some time in the future. Say you have 12 months to pay for a negotiable instrument and you look like you're going to default on that payment, then you can file an extension clause with the institution to try to get the negotiable instrument extended. So, non-negotiable contracts. A non-negotiable contract is a promise or order to pay that does not meet the requirements of a negotiable instrument. One of the key items is a non-negotiable contract is not subject to the same provisions of the UCC Uniform Commercial Code, specifically Article 3. A non-negotiable contract can be enforced under normal contract law. Basically, there are two different types of instruments, and the non-negotiable contract is not subject to Article 3 of the UCC. So let's talk a little bit about now the transfer by assignment or negotiation. If you're going to transfer the rights that you have under a contract, if you are the person that is transferring those rights, you're called the transferor or the assigner. If you're transferring it to another person, your rights to another person, they are the transferee or the assignee. If it's a negotiable rights, it's transferred to the holder. Okay, so if it's a negotiable instrument, you're transferring your rights to a holder of due course. So you can transfer your rights on a contract through negotiation, and that's transfer of a negotiable instrument by a person other than the issuer. It can be to the person to whom the instrument is transferred becomes the holder, and it's payable to a payee, and it has to have delivery and endorsement. So if you're going to transfer a negotiable instrument um, by negotiation, meaning that you're going to transfer it to another person, the person that you're going to pay, the payee, you have to have delivery of that negotiable instrument, and it has to be endorsed. Okay, and we'll talk a little bit about that as we go on. So, what is endorsement? You know, you've probably heard endorsement. Basically, you're taking a check or another piece of paper or contract, and you're signing it. And that's exactly what it is. It's a signature or other directions written by or on behalf of the holder somewhere on the instrument. Typically, on a check, the endorser will sign on the back of the check above the line. Uh, the signature may appear alone. For instance, Stephen, my name is Stephen W. Hughes, and I would sign that on the back of the check, and that would be considered an endorsement. And that would the signature would appear alone. The signature may name an individual to whom the instrument is to be paid. So in this case, it would be Stephen W. Hughes paid to Kevin Johnson. And the negotiable instrument, the endorsement, may have by accompanied by other words. You may have things like Stephen W. Hughes paid to Kevin Johnson the total amount of $5,000, or paid the amount of $5,000 today and another $1,000 in 30 days. So it can be accompanied by other words. There's really four types of endorsements. There's what's called a blank endorsement, a special endorsement, a qualified endorsement, and a restrictive endorsement. Now, a blank endorsement is basically, I'm sorry, there's five types of endorsements. Again, blank, special, a qualified, an unqualified, and then a non-restrictive. Non-restrictive. So I apologize for that. There's actually five types of endorsements. So let's talk a little bit about the blank. A blank endorsement does not specify a particular endorsee, and I could say pay to cash, for instance. So a blank endorsement basically is my name signed, and I'm not specifying the particular who I'm making this check out to. Now, a special endorsement specifies the person to whom the endorser intends the instrument to be payable to, and that creates what's called order paper. So, a special endorsement which identifies whom the instrument is going to is called creates what's called order paper. So I know you're going to see that again on a quiz or test. So an unqualified type of endorsement does not claim or limit liability. The endorser is liable on the instrument if it is not paid by the maker, the acceptor, or the drawer. So it does not limit liability. If you sign it as the endorser, then it's unqualified. You still have liability for it. Unqualified disclaims or limits the liability of the endorser, and there's really two types of unqualified endorsements. There's a special qualified endorsement, and then there's a blank qualified endorsement. A special qualified endorsement would signify who is liable and the limit that they're liable to. A blank qualified endorsement does not specify how much they're liable for. And then finally, you have a non-restrictive endorsement. There's no instructions or conditions attached to the payment or the funds. So those are the types of endorsements. And let's stop right there. I think we're about 30 minutes now in this section. You can take a little break, and we'll start back up. I'll have to download these in different sections, but this is our first video. Thanks.